Assalamualaikum, a very good morning. I am Sharija Shaari. Okay, my ID is FPEP11. Okay, I am going to present on behalf of my co-researchers, as you can see from the screen, a paper entitled A Doctrinal Study on the Definition of Native of Sabah and Appraisal. Okay, before I commence with my presentation, I would like to express our gratitude to UMS for funding our study under SDK 0065 2018 entitled Evolution of Native Courts and Customary Laws and Rights in Sabah. So this is a multidisciplinary research which comprises from law lecturers in FPEP and also and sociologists and law lecturer in social science. So it is estimated that there are 60 different ethnic groups in Sabah. Okay, and so this presentation focuses on the definition of native per se. So this is a legal study. Okay, so why it is important to be acknowledged as native? It is due to the special treatment given. For instance, the native customary land, the NCR, because if you are not native, we cannot buy the native land. And also when it comes to matrimonial or any disputes, they can be tried at the native court. So native courts only applicable to natives. So what are the issues here? Main issues is normally from it's land matters, because land is scarce. So the problem is that land, the native land, it has been in the family for so many generations, but it is based on they do not have torrent system, meaning that registered land title until we have the land ordinance. So meaning that it has been a family for ages, but it could be in the land office, the land belongs to no one. So the land is alienated to a company or to another party. So the one who's been planting or who's been using the land for ages, might take action against those who have the title. So meaning that there will be dispute between the native who's been using their native land, been cultivating their native in their native land, and those who have just been alienated the land from the land office. So there are many cases. So here, and there are also malafide among the public, so to the extent that they even forged the declaration or the certificate of native. And there are also issues of fraud, falsification or forgery of documents. So that is why it is important to go back to revisit, to appraise who is actually the native of Sabah. Because if we do not iron out this issue, so the native of Sabah might lose their rights, especially the land rights. So the main aim of this article is to revisit the definition of native of Sabah. So it is based on doctrinal study. So we would like to analyze whether the existing definition is sufficient or not. The research methodology, we are going to use legal methodology, meaning that we refer to the statutes, we refer to the cases, and we form an opinion. So this is summary how the research is being done. Before I go further, I would like to explain the hierarchy of courts in Malaysia, because later on I will share with you a few cases. If you do not understand the hierarchy of superior courts in Malaysia, then you might not be able to appreciate my explanation. So in Malaysia, only cases from superior courts are reported, meaning that there are The lowest, okay, in the hierarchy is High Court of Malaya and High Court of Sabah and Sarawak and Court of Appeal, and the highest court is Federal Court. Okay, so now we go into the discussion. Okay, in Malaysia, the highest law in the country is Federal Constitution. And in our Federal Constitution, Article 161A, okay, guarantees the right of native of Sabah and Sarawak. If you can see from the screen here, okay, for Sarawak, they have, okay, here it says that to one of the races specified in Clause 7, okay, Clause 7 here. But but for Sabah, okay, so who is native, okay, is not as specific as the definition in Sarawak. Okay, so here, as you can see, who is a citizen, okay, a child or grandchild of a race indigenous. But what is indigenous is not spelled out, and was born either in Sabah or to a father domiciled in Sabah at the time of the birth. So the definition is quite, I would say, very tricky. Okay, so here, okay, unlike Sarawak, here Sarawak they list out, okay, what are the races that can be considered as native. Okay, so now let's look at Sabah, okay, State Constitution, Article 41 in bracket 10. Here it sort of like reiterate what the Federal Constitution says. Okay, and then we have to refer to the excuse me, we have to refer to the interpretation in bracket definition of native, Ordinance Sabah, Chapter 64. Okay, so here it says, okay, Section 2 Sub 1 provides that A, any person both of whose parents are or were members of people indigenous to Sabah. Again, what is indigenous? It's not spelled out. B, any person ordinarily resident in Sabah, being living as a member of native community. Okay, one at least of whose parents or ancestors is or was a native within the meaning of paragraph A. And C, any person, okay, who is ordinary resident in Sabah and a member of this ethnic group. Okay, so here, and D, okay, any person who is an indigenous to Republic of Indonesia, the Sulu group, okay, and the State of Malaya and the Republic of Singapore, and live and been a member of the native community for at least 5 years, so they can apply, okay, to be certified as native of Sabah. Okay, so now if you were to refer to Section 2 Sub 2, here it provides that, okay, ancestor, okay, so it defines native community, defines parent, okay. However, here it says that, okay, for those who would like to be claimed or who like to be acknowledged as native, they have to fulfill this requirement. Okay, so Section 3 Sub 2 provides that any native court referred to in subsection 1 to whom an application is properly made under subsection shall have exclusive jurisdiction to entertain, meaning that when there is any dispute whether he or she is native, so we have to go back to native court because the ordinance empowered the native court to decide on this. Okay, and here the decision, okay, on any application made under subsection 1 shall be conclusive for all purposes. Okay, so now let's look at a few cases. Okay, in the High Court of, okay, in the High Court decision in the case of Mas Bakar bin Haji Hassan versus Government of Malaysia, okay, this was in 2010. So, okay, the plaintiff here is arguing, okay, whether, okay, he can be considered as people indigenous to Sabah or not. However, the court managed to establish that none of the plaintiffs testified that both parents are or were members of a people indigenous to Sabah, meaning that they do not fulfill the paragraph A which I have read to you just now. So because of, okay, the burden of proof is upon the plaintiff and they fail to do so, therefore they are not considered as native of Sabah. Okay, the next, okay, the problem with the interpretation, okay, ordinance is that the definition is too general, and we propose that there should be a list of Sabah natives, okay, as what is provided in Sarawak. Okay, so in the case of Liu Xiu Yin, okay, the applicant was Chinese and Dusun parentage. The applicant's father failed to justify a claim of having lived as a member of the community, because in order to be acknowledged as native Sabah, okay, they have to prove that they live as a member of community. Okay, but in this situation, he failed to do so because he was not resident in the community. He had married according to Chinese custom. His children bore Chinese name, and he had never paid tax, okay, in the village, meaning that he does not mingle with the people in the village. But okay, however, there is another case which I did not mention here. Okay, in the other case, it's almost similar to Liu Xiu Yin, but here, okay, that person is considered as native because, okay, even though he bore Chinese name, because he lived, okay, as okay, the way of his life is similar to the natives, and he mingled with the natives. Okay, now let's look at the latest case, that is Julita Tinggal. Julita Tinggal is actually a case land dispute, and whether the native court has the power, okay, to decide or not. So I'm not going to into the details. Okay, so now let's look at the decision. So in the High Court's, okay, the High Court's decision, okay, if in the Native Court of Appeal, okay, there will be one judicial commissioner, okay, which means High Court judge, okay, preside the case, and he will be assisted by two assessors, okay, meaning that two assessors from the, okay, who are the respected people from the community, okay, from the native community. So in these circumstances, there was, okay, the assessors decide differently from the from the judicial commissioner. So judicial commissioner, okay, so the judicial commissioner took the case. I mean, the judicial commissioner, there was, okay, an argument whether whose decision bind here. Is it the judicial commissioner who is legally trained, or the assessors? Okay, however, okay, the case went up to the High Court, and it was decided that the case, okay, will be decided based on the majority. So meaning that the decision made by the assessors prevail upon the decision made by the judicial commissioner. But okay, as I said earlier on, this is High Court's decision in 2020, and High Court decision is the lowest, okay, in the hierarchy of superior courts. So if there is an appeal, okay, to the Court of Appeal, so the situation might change. Okay, so meaning that the decision whereby the assessors or the native court judges, okay, override the judicial commissioner might not stand, okay, for long if there is, okay, a decision made otherwise in the Court of Appeal. So in conclusion, okay, we have, okay, point out that the interpretation of native is loose, okay, it's very vague. Okay, so therefore we put up recommendation, so that interpretation, definition of native ordinance should be amended, okay, to reflect, okay, the native, okay, the actual, okay, what is aspired by the native. Okay, so we propose that the section, okay, the removal of subsection C and D from section 2 sub 1, and also we recommended that, okay, in order to become a native of Sabah, they should also be the citizen of Federation of Malaysia. And we also suggest that, okay,